Thank you very much, Chairman Franks and Ranking Member Nadler. Thank you as well, Judiciary Committee Chairman Smith, and to the other members of the subcommittee for interest in this important matter. The Obama administration's decision to abandon its defense of DOMA, or more precisely to abandon its charade of pretending to defend DOMA, departs sharply from the Department of Justice's long-standing practice. Attorney General Holder's explanation of that decision cannot be taken seriously on its own terms. As the administration's broader sabotage of DOMA litigation makes clear, the Obama administration has subordinated its legal duty to its desire to please a favored and powerful political constituency, and is eager to obscure from the American public its stealth campaign to induce the court to invent a constitutional right to same-sex marriage. Let me briefly amplify these points. With the exception of laws that intrude on executive branch power, the long-standing practice of the Department of Justice is to vigorously defend the constitutionality of any law for which a reasonable defense may be made. This reasonable standard sets a very low bar. It basically means that the Department will defend a federal law when it can offer non-frivolous grounds in support of the law. In other words, when the law is not patently unconstitutional. As Clinton administration Solicitor General Drew Days has explained, this reasonable standard affords Congress the respect to which it is entitled as a coordinate branch of government, and prevents the executive branch from using litigation as a form of post-enactment veto of legislation that the current administration dislikes. Attorney General Holder claims to have acted consistent with this standard, but his claim is clearly wrong. Any competent lawyer could present plenty of reasonable arguments that DOMA shouldn't be subjected to heightened scrutiny. Indeed, all 11 federal circuit courts to address the question have determined that classifications based on sexual orientation are subject to rational basis review. Any competent lawyer could likewise present plenty of reasonable arguments that even if heightened scrutiny were to apply, DOMA would satisfy that standard. For all its flaws, the Obama administration's decision to abandon its formal defense of DOMA has the modest virtue of making overt a far greater scandal that the Obama administration has been attempting to obscure, namely that the department has only been pretending to defend DOMA while it in fact has been actively sabotaging it. Most starkly, in 2009, in what a supporter of same-sex marriage aptly described as a gift to the gay marriage movement, the Obama administration affirmatively repudiated the argument that DOMA is rationally related to legitimate governmental interests in responsible procreation and child-rearing. Never mind that these grounds had proven successful in previous litigation against DOMA and had been invoked by Congress when it enacted DOMA. Not surprisingly, the lone judge to rule against DOMA relied heavily on the department's concession. Last fall, Assistant Attorney General Tony West admitted that the department was modifying and diluting its legal arguments in DOMA cases to comport with what he called the Obama administration's policy values. According to a sympathetic account of his remarks, Assistant Attorney General West also disclosed that the department was working with its, quote, liaison to the gay, lesbian, bisexual, and transgender community to make sure that future briefings don't advance arguments that they would find offensive, end quote. In other words, a senior DOJ official was conceding that the department was allowing the sensitivities of a favored political constituency to have extraordinary influence over how the department defended or pretended to defend DOMA. In sum, far from providing the vigorous defense of DOMA that it promised, the Obama administration undermined that litigation for the obvious purpose of pleasing a particular political constituency. President Obama won election to his office maintaining that he opposes same-sex marriage and keeping contrary evidence buried. Even now, he and his administration are attempting to obscure that his position that DOMA is unconstitutional clearly means that he also believes that traditional marriage laws are unconstitutional. Given the Obama administration's dereliction of duty, the decision by the House of Representatives to step in to defend DOMA is entirely warranted. Indeed, that decision should be supported as a matter of principle by all House members, whether or not they support DOMA. The department's irresponsible course of action is fully to blame for the House's need to incur legal fees in defending DOMA. Thus, although it's refreshing to witness concerns of fiscal frugality from some members of the House not ordinarily associated with such concerns, those concerns are misdirected if they're deployed to question or oppose the House's retention of counsel. The far more sensible course is for the House to make clear that the sum to be appropriated for the department will be reduced by the sum expended on legal fees in defense of DOMA, or better yet, by some healthy multiple of that sum. Thank you.